Good afternoon, I'm Ini John McQuarrie. Let's do business. Starting from the global space, oil prices were stable on Monday after the United States and Iran pledged to continue indirect talks, easing oil supply fears. But India, stepping away from Russian oil purchases, is giving prices a floor, retracing earlier losses. And so we see for this afternoon, Brent is just slightly up, 0.04%. The price is $68.08 a barrel. For WTI, is also up 0.06% at $63.60 a barrel. And then also, after those talks that started on Friday and more talks expected, Brent and WTI fell more than 3% and 2% respectively last week, their first decline in 7 weeks as tensions eased amid a broader market sell-off led by equities. However, the foreign minister of Iran said the country will strike U.S. bases in the Middle East if it is attacked by U.S. forces. Let's talk about what all of this is doing to Nigeria, which we know has its mainstay in the oil and gas for its revenue, national revenue, that is. And then Nigeria, of course, has that target of 2 million barrels per day for 2026. However, recently there's been talks about the Petroleum Industry Act and issues coming around that may threaten this target. Let's have this conversation now with Liberos Oshoma. He's a lawyer and public affairs analyst. Mr. Oshoma, good afternoon and welcome to the program. Good afternoon, Mr. Oshoma. Can you hear me?
Yes, I can hear you. Good afternoon.
Great.
Can you hear me?
Yes, I can hear you now. So Nigeria has a target of 2 million barrels. Last year, we couldn't mostly meet up even with the OPEC quota. Now we have 2 million. But now the threat coming from the PIA, which is supposed to be helping matters, is also being considered and of great concern. What have you heard about this? What should we be doing about this?
Yeah, thank you very much. Ordinarily, the PIA was meant to strengthen the operations of our marginal feeds and then also operations of the sector generally. But like typical of our businesses, you find out that the human factor, and in some cases, when I mean human factor, some of the litigations as regards the operations of the PIA and also the regulators, the inability of the regulators to enforce law strictly. It also will act, if not properly handled, will act as a inhibition to the operations of the PIA. And I say this advisedly because recently, you remember the case of Eurafric and the Petrolan Energy Limited, and the decisions of the Federal High Court in that matter. I think that the regulator ought to have put its foot, strongly down, before all of that happened. Because if you remember, before some of these licenses were reissued, some of the feeds had been inactive for a very long time. Some for 7 years, some for 5 years, especially that operated by the Eurofeed, and then before the PIA came into being, some of these licenses were revoked. And immediately the PIA came into being, Section 96 spells out clearly also how, some of these licenses, like the OML can be revoked, including OPL. But in as far as that case is concerned, though the license was revoked before the coming into effect of the PIA, yet the parties went to court gave a judgment, and then it was as if the regulator, the NUPRC was, footy-pussy, and they allowed all of that. And that will further inhibit investment in that sector. And I say this, a situation where an operator is given a license and the feed is inactive for years. And then you will now have an operator, the Petrolan, who had been, sweating the feed to, in the last 1 year, has sweated the feed to about 150,000 barrels for two wells and another well in the offing. And yet you have, such, a litigation hanging over their head. What the what do you call it, the operators or the regulators should have done would have been to call parties to a round table and resolve the matter timely so as to encourage, the target that the federal government has set. In the absence of that, certainly, people wouldn't want to invest in those feeds that were revoked.
And just at the just concluded energy summit in Abuja, the minister was very proud of the fact that, or at least the claims that we have now started attracting more foreign investment funding capital into the oil and gas space. So I wonder, when you place that side by side with this, some of this judiciary, well, not very good sentiment, I wonder what that would do to us and what that would do to that claim by the minister.
Yeah, we need to understand that an environment where litigation are drawbacks, no matter how lucrative investment in those areas are, no business would want to fully invest in that. That's why when the minister, I listened to the minister's speech, and why the minister is happy that investors are interested in coming to invest in the sectors, and some of these investments are yielding result. And one of such investment that is yielding result is the well by Petroland. Like I said, a well that was redundant for 40 years, and all of a sudden, within 1 year, it's been sweated to a 150,000 barrel. So, but then what needs to be done? You remember, El-Rufai once said that when he became the minister for the FCT, he knew that certain decisions were going to be taken. So there must be understanding between the agencies and the judiciary. Also, what the AFCC does, organize trainings for the judiciary most times to understand their modus operandi, and also understand the technicalities and intricacies of the applications of their laws. So I think the NUPRC and the minister also need to organize such seminars, collaboration between the Ministry of Petroleum and Natural Resources and Gas, and then the judiciary, so that people or some of these judges would understand the intricacies. Because even if you look at Section 99 that the High Court hinges judgment on, Section 99 talks about an operator and a default operator. Section 96 specifically talks about where the awardee had not been paying royalty. In this case, royalty for a long time was not paid to the federal government, and it was like the asset was redundant. So what the government need to do in that stead is what they did, to have revoked that license even before the coming into effect of the PIA. But like I said, there are so many, the PIA is a novel piece of legislature that even some courts don't even understand. So there's need for that synergy, that collaboration, lectures and seminars, so that there'll be more understanding. That will also deepen and encourage the investment in that sector and help the federal government to meet its target. Otherwise, investors are going to come, and with these kind of challenges, they are certainly going to, take a backtrack.
Yeah, Mr. Shoma, so you think it's the lack of adequate knowledge and not sentiments or, some selfish gains that's informing all of this?
Yes, I think that, in most cases, interpretation, depending on, like we say, depending on the chancellor's foot, depending on the mind of the court. If the mind of the court is broad, then certainly interpretation will be very broad. But if the mind of the court is narrow, that takes us to understanding, then that interpretation will be narrow. So, and then also coupled with selfishness that we have in our system. So that's why the judiciary at every point needs to understand that decisions such as this will also limit the investment in the oil and gas sector.
All right. Thank you so much, Mr. Liberal Soshoma, a lawyer and public affairs analyst.
My pleasure. Thank you, Ini.